Welcome to the Dealmaking with Laura DiFrancesco podcast. I'm Laura DiFrancesco, your host. We're talking all about mergers and acquisitions, buying and selling small businesses, as well as corporate law. We are taking our experience closing over $10 billion of transactions since founding Dean Street Law 5 years ago, and my experience being an M&A and corporate attorney for over a decade and making it accessible to you as an entrepreneur. I hope that this helps you in navigating the complex world of mergers and acquisitions. And also, we're always happy to be a resource for you here at Dean Street Law. You can always apply to work with us through our complimentary consultations linked in our show notes. And a huge shout out and thank you to everyone who's subscribed and left us a 5-star review. If you haven't yet, be sure to subscribe and also leave us a 5-star review. It's one of the best ways to support us as a small business. And also be sure to share with your friends and colleagues on social media, through text, email, or however is easiest. It means the world to us that you're supporting our content and helps us make more to support you in your journey. Welcome back to the latest episode of the Dealmaking with Laura DiFrancesco podcast. I'm your host, Laura DiFrancesco, founder of Dean Street Law, where we've closed over $10 billion of transactions. We specialize in mergers and acquisitions and entrepreneurship through acquisition, and have a full team to support you, whether you're buy side or sell side. In addition to that, I'm also founder of Ethereal Farms, Flourish Co-working Event Space, Laura DiFrancesco LLC, where we have our education platform with acquisition insights, and our book, Entrepreneurship Through Acquisition, a legal guide to buying a small business. So if you haven't checked it out yet, be sure to download the first chapter, get on the wait list. It's coming out soon, so you can hear all about it. And I'm excited to talk about today's topic. Today's topic is all about the change of control provisions and the anti-assignment provisions that you'll see in contracts of a target company. So whether you're buying a business or you're planning to sell your business, it's really important to understand those change of control and anti-assignment provisions, because ultimately, not only will they drive your deal structure, but they'll ultimately drive your timeline, third-party consents that are needed, complexity of the transaction. So a lot of the time, buyers and sellers want to on their own independently decide, well, this is going to be an asset purchase, it's going to be a stock purchase, but sometimes you just don't know, or at least you can make an educated guess and state a desire, an intention between the parties, but ultimately that will need to be resolved in due diligence. So let's chat more about this topic so that if you are pre-LOI, you can start asking these questions. If you're preparing your business for sale, you can start looking through your contracts to see, am I going to have issues in transferring the business? How will this drive the structure? And ultimately complexity and timeline of the transaction. So what is a change of control clause? What is an anti-assignment clause? Generally, most contracts will have some sort of language to address assignability, change of control. Basically, the expectation when you enter into a contract, particularly material contracts, vendor contracts, material customer contracts, there's an expectation that you will continue to do business with the same party, and the terms that you've negotiated are for that party alone. And so oftentimes you'll see either the contract is not assignable without notice to the other party or consent of the other party. Sometimes it's silent on assignability. Sometimes it says that if there is a change of ownership or change of control over the contracting party, that requires consent or it requires notice of something like that. So let's talk about those provisions in detail. Generally, absent any of these provisions, a contract is assignable, meaning that if you are doing an asset purchase of a business, or if you're selling your business as an asset sale, then the business is going to have to transfer all of its different classes of assets via separate mechanisms, depending on those types of assets. A personal property transfers via bill of sale, a car transfers via the title, real estate transfers via deed, contracts transfer via assignment of contracts. So in order to assign those in an asset sale, you have to have permission from the contracting party to assign them. If the contract is silent, it does not have an anti-assignment clause. It does not have anything regarding assignability. It does not have anything regarding change of control. The default in most states, but we would clarify that and research for your specific state of the target company and the controlling law of the contract. The default is that it is assignable. So meaning the seller can assign by assignment of contracts that contract to the buyer. Now that's an assignment, the lack of an assignment clause, right? But an assignment clause is going to say either you can assign the contract and the contract endures and becomes applicable to future successors in interest, or it may say that you cannot assign it at all, or it may say you cannot assign the contract without the consent of the opposing party in the contract, the contracting party, or it may say that you cannot assign the contract without notice to that contracting party. Ultimately, this is oftentimes negotiated based on the negotiation leverage of the parties. And whether this is consequential is going to be different, whether this is your click wrap contract of Microsoft Office versus your material contracts with your material customers. A change of control provision is going to say something to the extent that if there is a change of control, a change of ownership of more than 50% of the business, then it requires either consent of the contracting party or the notice to the contracting party. They matter because ultimately in a change of control, that's going to be where you have a stock purchase or a membership interest purchase. So that's going to be relevant in that type of transaction, and an assignment clause is going to be relevant in an asset purchase or an asset sale. Now, sometimes there are provisions with language around deemed assignment. And so how a equity sale or a sale of a business will be deemed an assignment, which is kind of bridging the gap between a change of control provision and an assignability provision, meaning that we will consider a change of control actual assignability, and then it may be subject to those rules around assignabilities. We're going to provide examples from real contracts. I'm going to pull up a couple of those. So what are the implications for the buyers? If you're buying a business, you want to make sure that material contracts with customers, contracts with vendors, other material contracts in the business, such as loans that are going to be assumed, leases that are going to be assumed, you want to understand how they are assignable, what their change of control provisions are. In due diligence, we review all of those. And there is a risk of losing key customers, key suppliers, key loans, key financing and leasing through the change of the sale of the business, whether that's an asset sale or a stock sale. The difficulty in transferring contracts, because contracts tend to be a major component of value in the business, is that ultimately it will impact the value of the business. It will also impact due diligence. It's something right away that we're requesting as soon as we're on an engagement. We request that in our due diligence request list. We prioritize that because assignability, review of assignability and change of control drives timeline and drives third-party involvement. So most of the time, the solutions are a few different things. You can negotiate solutions between the buyers and sellers. First, if consent or notice is needed, you may seek that consent or notice. Now, that involves bringing in third parties into your transaction that will ultimately influence whether the deal can be done. Sometimes, depending on how important or not important the contract is, the parties may decide to risk it and obtain that consent or complete that notice post-closing. Or the parties may decide to risk it entirely. You see this more in the click wrap contracts, or maybe it's a printer lease or something non-consequential. They may risk it entirely and say, we're just not going to obtain that consent. Effectively, the contracting party will likely never notice whether there was an assignment or whether there was a change of control. But that is the parties consciously deciding to breach the contract. So that's important. Otherwise, they may need to change the structure from an asset purchase if there's anti-assignment but no change of control provision. They may need to change the structure from an asset purchase to a stock purchase to eliminate the need of third-party consents, because ultimately that's going to jeopardize the deal, put the deal at risk for their consent. There may also be reps and warranties, representations and warranties, that there are no change of control or assignment provisions other than those that have been listed. That's important because ultimately the buyer can only review the documents that the seller provides. And if the seller doesn't provide a material contract, the buyer won't know that there is a change of control or anti-assignment provision. And then we talked about absorbing the risk of not obtaining consent. So the best practices to address this is 1, early contract review. This should be first and foremost, immediately after the LOI is signed, we're getting copies of all the contracts. If you're on the sell side and you haven't listed the business for sale, or you're planning to list the business for sale, definitely have an attorney or go through it yourself. We do pre-sale preparation to maintain exit value. So make sure you're going through or working with an attorney or us to go through your contracts to review assignability, change of control, so that they don't pose issues for the transfer of the business. And then all of those consents or notices that we need to provide are all going to go into our closing checklist and timeline. We're going to put together a whole notice and consent checklist, analysis, and then we'll also plan and work with the parties to plan through contingencies. So I'm going to go over a couple different examples on change of control and anti-assignment provisions so we can talk a little bit more in depth on these. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion-dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com in the show notes to schedule a complimentary consultation. All right, here's some example of assignability and change of control provisions. Assignment of interest under this policy shall not bind the company unless its consent is endorsed hereon. So that's something where basically consent is not required, but if you want the benefit of the policy, then it must be obtained. So that's something you might see in an insurance policy. Another example is your rights and duties under this policy may not be transferred without our written consent, except in the case of death of an individual named insured. If you die, your rights and duties will be transferred to your legal representative, but only while acting within the scope of duties as your legal representative. Until your legal representative is appointed, anyone having proper temporary custody of your property will have your rights and duties, but only with respect to that property. So in an M&A situation, that specific assignability clause would require written consent for this policy, which is, again, an insurance policy, to transfer. The next one, let's go with something a little bit different. We have a couple of those different policies. Let's see. Let's go with a loan. With respect to the loan examples, you shall not sell, transfer, assign, encumber, pledge, or lease the equipment or this agreement without our prior consent. So any of those would be in an asset purchase. The next, meaning in an asset purchase, all of those would require the consent of the lender. It also says you shall not consolidate or merge with or into any entity, distribute, sell, or dispose of all or any substantial portion of your assets other than in the ordinary course of business without our prior consent. So again, asset sale requires prior consent. It continues to say, and the surviving or successor entity or the transferee of such assets as the case may be shall assume all of your obligations under this agreement by a written instrument acceptable by us. It goes on to say, no event shall occur which causes or results in a transfer of majority ownership of you while any obligations are outstanding hereunder. We may sell, transfer, or assign this agreement without notice to or consent from you. And then it continues on. So basically the first couple of sentences were with respect to anti-assignment clauses, saying that any assignment, any asset sale of the business requires consent of the lender. Then it goes on to say, no event shall occur which causes or results in the transfer of majority ownership of you while any obligations are outstanding hereunder, meaning that a transfer of ownership is expressly prohibited. Then it goes on to have the bank's transfer rights, which is we may sell, assign, or transfer this agreement without notice to or consent from you. So they have the ability to transfer the agreement wholesale. You as the borrower do not. So oftentimes you'll see that these are negotiated components, oftentimes a result of the negotiation power of the parties. That goes on to say that you agree that if they sell, the lender sells, assigns, or transfers the agreement, their assignee will have the same rights and benefits that they have now and will not that we have now and will have to perform any of our obligations. You agree that our assignee will not be subject to any claims, defenses, or offsets that you may have against us. This agreement shall be binding on and inure to the benefit of the parties hereto and their respective successors and assigns. So that's a big provision that includes anti-assignment, anti-change of control. It doesn't even say that you can transfer the ownership of the business with their consent. It says expressly that you can't transfer the ownership of the business. So in that situation, we would then need an amendment of the agreement whereby they agree to not only waive that provision, but also consent to the assignment. Another couple examples are, this is with respect to a few more loans. We may sell, assign, or transfer this agreement and the equipment without notice. The lender has quite a lot of rights. You agree that if we sell, assign, or transfer this agreement and the equipment to a lessor, such lessor shall have the same rights and benefits that we have now and will not have to perform any of our obligations. You agree that the rights of such lessor will not be subject to any claims, defenses, set-offs that you may have against us, whether or not you're notified of such assignment. The cost of any equipment, software, services, or any other elements of this agreement has been negotiated between you and us. None of the lessor and lessor assignees will be providing funding based on the payment you have negotiated with us. You're responsible for determining your accounting treatment, So that's another financing agreement for a lease. This is with respect to another loan. Subject to any limitations stated in this agreement on transfer of grantor's interest, this agreement shall be binding upon and inure to the benefit of the parties, their successors, and assigns. If ownership of the collateral becomes vested in a person other than grantor, lender without notice to grantor may deal with grantor's successors with reference to this agreement and the indebtedness by way of forbearance or extension without releasing grantor from the obligations of this agreement or liability under the indebtedness, meaning that even if you transfer this contract or the underlying interests in the secured property, the lender will still have a right to come against you. So if you want to extinguish those rights, you're going to have to amend the loan documents. So those are just a couple examples. We put together, this is an example of an assignability chart that we put together for our clients, outlining all of the different assignability provisions in the contracts of the business that they are looking to purchase, whether by asset purchase or stock sale. So whenever you have the transfer of a business, the transfer of assets of the business, you always have to make sure that each class of assets, the equity ownership itself will not trigger anti-assignment or change of control provisions. At Dean Street Law, this is something we're very focused on from the beginning of an engagement. As soon as an LOI is signed, if you're in the position as a seller to work on this prior to selling the business, that is the best thing that you could do to position your business well. It will help you identify, okay, I might have to pay these loans off before closing, or if they're really advantageous, I may need to work with my lenders to transfer the business and get authorization to transfer the business, because the buyer may want to purchase the business subject to certain indebtedness if the seller has great terms that they would like to inherit. So these are all things that we negotiate, we talk through, we work out in the engagement. If you'd like to chat more about this, be sure to schedule a consultation call with us at Dean Street Law. The link is in the show notes. Thank you so much for joining me for this episode. I hope you subscribe and tune in for more episodes of Deal Making with Laura DiFrancesco. Cheers and happy deal making. Thank you so much for joining us on this episode of the Deal Making with Laura DiFrancesco podcast. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please be sure to follow and subscribe to Deal Making with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please leave a 5-star review. It would mean the world to us, and share this podcast with your network, friends, and colleagues. For more in-depth resources, be sure to visit our website, deanstreetlaw.com, where you can find articles, guides, and more information on our services. Don't forget to follow us on social media for the latest episodes, updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Join us on our next episode where we'll explore more deal-making insights. Cheers and happy deal making.